My name is Deanna Carpenter. Today we will discuss two United States Supreme Court cases. These two important cases illustrate the difference in freedom of speech and freedom of the press in regards to private citizens and public figures. Our first case is the New York Times Company v. Sullivan. On March 29, 1960, a full-page advertisement was published in the New York Times alleging the arrest of Reverend Martin Luther King Jr. for perjury in Montgomery, Alabama, was part of a campaign to destroy King's efforts towards public integration and encouraging blacks to vote. The ad, titled "Heed Their Rising Voices," was paid for by the Committee to Defend Martin Luther King and the Struggle Freedom in the South. Montgomery City Commissioner L.B. Sullivan filed a libel lawsuit against the newspaper claiming the allegations against the Montgomery police defamed Sullivan personally. At the time of the arrest and placement of the ad, Sullivan's duties included supervising the police department. Sullivan felt the statements in the ad referred to Sullivan directly due to his supervisory duties. Before we discuss the actual case, let's take a look at the key elements of defamation. Defamation is a false statement that injures a third party's reputation. Libel is written statements of defamation. There are four key elements of defamation. 1. A false statement purporting to be fact. 2. Publication or communication of that statement to a third party. 3. Fault amounting to at least negligence, though public figures must show the false defaming statements have been said with actual malice and proved with clear and convincing evidence instead of merely preponderance of the evidence. And 4. Damage or some harm caused to the person or entity who is the subject of the statement. As Sullivan was a public official, Sullivan needed to prove the New York Times had knowledge of or reckless disregard of the false statement, that the New York Times acted with actual malice when publishing the advertisement, and Sullivan had to prove this by submitting clear and convincing evidence. While the trial court and Court of Appeals found in favor of Sullivan, the case made its way to the Supreme Court. The United States Supreme Court reversed the lower court's decision and remanded it back to the state court. Sullivan's argument that the 14th Amendment is directed against state action and not private action had no application to this case. The Supreme Court stated the Alabama courts have applied a state rule of law which the New York Times claimed to impose in a civil action that is common law only. The second argument relies on Valentine versus Christensen. The constitutional guarantee of freedom of speech and freedom of the press is also irrelevant to this case. The publication in question here was not a commercial advertisement in the same fashion as the publication at the center of the Valentine versus Christensen case. The New York Times ad sought to communicate information, expressed opinion, and grievances and protest claimed abuses. The matters discussed in the New York Times ad were of public interest and concern. The fact that the New York Times was paid for the ad is irrelevant. Freedom of speech and freedom of the press are protected by the First and 14th Amendments in a libel action brought by a public official against his critics. To find in favor of Sullivan would discourage newspapers from printing editorial ads. This action would cut off the average person's access to publishing facilities, limiting their ability to exercise their freedom of speech. Now let's look at a case involving a private individual and libelous statements. Elmer Gertz was a lawyer hired to represent a family of a young man murdered by a police officer, Richard Nuccio. The family brought a civil action against Nuccio. Gertz is considered a private citizen. Robert Welch Incorporated ran an article in their American Opinion publication about Gertz. The article contains several defamatory statements, including Gertz led a communist conspiracy to discredit local police, Gertz arranged for Nuccio to be framed for murder, implied Gertz had a criminal record, labeled Gertz a Leninist and communist fronter, and claimed Gertz was an officer of the National Lawyers Guild, which the article described as a communist organization. The managing editor of the American Opinion made no effort to verify or substantiate the allegations against Gertz. Instead, an editorial introduction was included stating the article and author, quote, had conducted extensive research into the Richard Nussio case. While we can look back on Gertz's career and see the case did not negatively affect his reputation, at the time of the lawsuit, the nation was involved in the Vietnam conflict. Communists were the enemy, and if you were labeled a communist, it could destroy your reputation as well as your career. This lawsuit could have easily been avoided had the managing editor of the American Opinion taken steps to verify the information contained in the article. If the information could not be verified, then the article should not be published. Each state has their own defamation laws. The elements of defamation in Missouri are the publication of a defamatory statement identifies the plaintiff as false, that it is published with the required degree of fault, and that the statements damage the plaintiff's reputation. What have we learned from these cases? Freedom of speech and of the press are different depending on if the subject is a public figure or private individual. When writing about a person, you should determine which they are. Regardless of the subject, you should always verify information contained in articles before publication. And defamation laws vary state to state. Make sure you know yours.